With respect to slip and falls in big box stores like a Walmart or a Target, what I've learned from other attorneys that have successfully litigated these cases, even winning verdicts of more than $40 million in one case, is that one of the things you have to really look out for is that the policies and procedures, such as a facility protection plan, comes from the corporate headquarters in one particular location. But the way they do it is that that corporate office is only giving the policies and procedures as a one-way to each individual store, right? That these stores could be in all 50 states. So it's going one way. But then if something happens, let's say in a store in one state, let's say in New York, and then they know about this happening and they get it back from the store, the corporate headquarters does, but they don't use that information to then make another store in a different state safer, such as California. The same thing could happen in California because they don't use it that way. And then when you're in litigation with them, you can point that out because you're not able to obtain information as to what happened. Let's say there was an unsafe condition in one store and the same exact thing happened in another store. Well, they won't have that because they treat each store as its own island, as a standalone. But that's a choice they make as a corporation, right? To insulate themselves from notice, because notice is something you have to prove in order to win a case. So when you understand that, you could really expose them and make them look as a bad corporate actor, which they are, by creating this type of system and this type of structure. So it's very important to hire an attorney that knows how to handle these cases and has experience with these cases. And that's the way that you could get many millions of dollars in lawsuits against big box stores.